Good afternoon, everyone. My name is Daniel Saber with the United Kingdom's Government Communications Headquarters, or GCHQ for short. Thank you for the opportunity to provide testimony today before this committee on the cyber incidents that have affected the global economic summit.
What are the legal challenges associated with cyber incidents involving foreign countries?
When a cyber incident involves other countries, the situation becomes much more complicated. From a forensic standpoint, there are two main legal issues. The first is data privacy laws, and the second is determining who actually has authority during the incident. Many countries, including every member of the Five Eye Alliance, except for the United States, have data protection and privacy laws. And these laws are something that we as incident responders have to consider, have to abide by even during an international cyber incident. We have to be familiar with the laws of the country whose data we are handling. And these laws usually have breach notification requirements. An appropriate governing body in the UK, this is the Information Commissioner's Office, must be notified within a certain amount of time. In the UK, we have 72 hours from the time the incident is discovered to report that to the ICO. This is covered in Recital 87 and Article 33 of the UK GDPR. And if the incident affects multiple countries, there are now multiple entities that have to be notified within their own time frame. So these are not always the same. Some may be shorter than others. I believe the United States is 24 hours, maybe even less than that. And there is usually a fairly significant amount of information that must be provided in the notification. In regards to authority, a country's data privacy laws will not simply allow a foreign entity to just come in and perform an investigation on its networks. If an incident affects our nation and we discover evidence that suggests the attack was sourced from inside another nation, we get a situation where we may have to rely on the other nation to conduct the investigation unless that nation is willing to give us access to their systems. So we have a level of inherent trust that is required in the other nation to conduct a proper and thorough investigation.
You mentioned how a country's data privacy laws won't allow foreign entities to perform investigations. So how do international laws affect e-discovery?
Going back to data privacy laws, these laws generally include clauses regarding e-discovery and foreign entities. Usually these laws will only permit the release of data to foreign entities, whether that's law enforcement or some other group, if the receiving nation can demonstrate that they will keep that data safe in a manner that complies with the regulations of the country that is sending the data. In the UK GDPR, this is specified in Articles 44, 45, 48, and 49. Transfers to countries outside of the UK, referred to as third countries in the GDPR, are only permitted where the conditions specified in the UK GDPR are met. Article 48 specifically mentions that transfers demanded by courts outside of the UK are only enforceable where they are based on some sort of international agreement, such as a mutual legal assistance treaty between the third country and the UK. Any transfer in response to such a request where there is no other legal basis for the transfer will infringe the UK.
What are the legal challenges of accessing and retrieving electronic evidence stored on foreign soil?
Again, data protection laws, in particular the UK GDPR, have very strict requirements about transferring and accessing personal data. If electronic evidence is stored in a foreign system and there is a need to access that evidence, we would need to work within the confines of that country's data protection laws. Unless there is language in the law that covers prior authorization or extenuating circumstances or mutual assistance or some other reason which gives us legal authority to conduct our investigation in that country on those systems, there is nothing that openly authorizes us to access another country's systems and start investigating.
Thank you for that explanation. Now, assuming cloud storage was used, what procedures were followed to access and retrieve digital evidence stored in the cloud?
If the cloud provider is not a UK company, if it's a foreign company, our scope of actions would be limited. We would need to work with the country the company is based in to obtain that evidence. If the cloud provider is based in the UK, then the UK's Investigatory Powers Act, which grants electronic surveillance powers to British intelligence and law enforcement, applies. Cloud providers within the UK that are based in the UK fall within the language of the Act. And GCHQ is one of the authorities that is allowed to access internet connection records in the UK without a warrant. So in the case of cloud evidence, GCHQ would employ a tactic called targeted interception on the cloud provider's physical servers to obtain the evidence needed. The provider would be required to assist with this interception, as well as remove any encryption that would hinder the retrieval of that evidence. The Investigatory Powers Act does not grant, or does not force these obligations, rather, on foreign companies. So again, with a foreign company, even though they may be doing business in the UK, the extent of our capabilities would be limited to working with the provider.
Specific to the United Kingdom, how did the international laws and jurisdictions influence the processes and procedures followed during the forensic investigation?
From our investigation, the ransomware incident was isolated to a single HR employee's workstation. This HR employee was internal to the United Kingdom, and during the investigation, we did not encounter any evidence that demonstrated the malware crossing over international borders. Given that the summit was also hosted in the United Kingdom, international laws did not influence the forensic investigation.
What conflicts arose between ethics and international laws during the forensic investigations? How did these conflicts affect the investigations? And how were the conflicts mitigated?
During our investigation, we did not encounter any ethical issues or issues between ethics and international laws. HR was very forthcoming when we were made aware of the attack. Every team involved in the response acted in a completely ethical and professional manner. Again, the attack was completely internal to the UK's network at the summit, so any international laws would not have applied in this case. Only the UK GDPR and the Data Protection Act of 2018 applied in this case.
What steps were taken to protect United States soil and citizens during the international investigation? Please describe any risk to the country, businesses, or citizens from your investigations.
As I stated previously, the summit took place in the United Kingdom, and the ransomware incident affected only a single workstation that was on the UK's network at the conference. There was no evidence of the malware crossing international boundaries. We saw nothing of that sort during our analysis. So, given the physical location of the summit and the extremely small scale of the attack, it is my expert opinion that the United States and its citizens were never at risk of being affected by the malware. The malware in question is almost a decade old at this point, and in the process of remediating the affected computer, we actually obtained the program used to reverse the malware's encryption. Scanned the network after remediation did not reveal any additional infections, and any infections we would have encountered would have been quickly resolved due to having the decryption program.
All right. Thank you, Daniel. That is all the questions that we have for you today. Thank you for coming before this committee to provide your expert opinion by testifying.
Thank you again for this opportunity. I would like to applaud the personnel involved for their swift and knowledgeable response to this incident. Their efforts spared the summit from a potentially worse threat. I hope my testimony today will be of use to the committee in their future efforts to secure our infrastructure and systems against further cyber incidents.